Dzisiaj jest dzień szczególny, dlatego że 10 grudnia to jest Międzynarodowy Dzień Praw Człowieka. Zaczynamy nasz kolejny panel i przekazuję mikrofon panu doktorowi Klausowi.
Dzień dobry Państwu. Włączonej słuchać nie mam nadzieję, czy niekoniecznie. Słychać, przepraszam. Tak? Dobra. Dzień dobry Państwu jeszcze raz. Przepraszamy za lekkie opóźnienie, ale w związku z tym, że jest sobota, blady świt, to musimy dać szansę osobom, które dojdą i się lekko... Trochę nieludzkie jest rozpoczynanie konferencji w sobotę w tak wczesnej godzinie. Witam Państwa na panelu, który dotyczy związków między równością a prawami człowieka. Razem ze mną w panelu mamy jeszcze dodatkowo troje gości. Panią profesor Renatę Uitz, która jest profesorem prawa konstytucjonalnego porównawczego na Centralnym Uniwersytecie Europejskim w Budapeszcie. Panią Alexandrę Nuno, która jest dyrektorem programu dla Ameryki Środkowej i Meksyku w Center for Justice and International Law. I pana doktora Jean-Pierre Gauci, przepraszam, który jest dyrektorem People for Change Foundation i jest również konsultantem w European Network Against Racism. To, na czym się będziemy się dzisiaj skupić, to pokazanie, jak wyglądają relacje pomiędzy prawem antydyskryminacyjnym a prawami człowieka i w jaki sposób dążymy do zagwarantowania równości wobec prawa dla wszystkich osób. No i myślę, że to my skupimy przede wszystkim to pytanie, czy życie dla wszystkich, czy rzeczywiście gwarantujemy równość wszystkim, czy są grupy, które będą pominięte w tym systemie, oraz nawet jeżeli formalnie pominięte nie są, to czy może jest tak, że w praktyce ta równość wobec nich nie działa. To tyle może do takiego wstępu i poprosiłbym w takim razie panią Renatę.
Thank you very much. I would like to thank the Polish Helsinki Foundation to invite me. This is not the first occasion when I'm speaking at one of the events organized by the foundation, and I would like to again thank for the chance not only to speak to law professors but also to students and human rights activists. My comments in this panel and in the next panel will be influenced not so much or not only by teaching human rights but also being involved in various organizations who protect rights of people who I deem are especially vulnerable. My research involves mostly religious minorities, and my advocacy deals with sexual minorities and mentally disabled people. So I think it's fair to reveal that this is where most of the comments will come from. When it comes to human rights and equality, very often we see this as a problem of improving the ability of the human rights regime in addressing not only discrimination but also systemic structural disadvantage. And ultimately, but this is something which is easy to lose sight of, ultimately we aim to tackle prejudice which is fueling discrimination in a lasting and systemic and structural manner. The reason why I'm restating the original starting point is that human rights law and equality law and anti-discrimination law came to have developed into two almost separate fields, and different people deal with anti-discrimination law, and if you go to a conference of human rights you won't see them because they are the anti-discrimination guys, and vice versa. Actually, when you look at anti-discrimination law, very often you see that you have a very, very widespread and deep legal framework, which is unusual for human rights law. You have many, many international conventions, regional conventions, and national legal instruments addressing equal protection problems or anti-discrimination problems. I don't distinguish between the two. So if you look at any developed legal system, you will see civil codes, rules on contract, rules on services, the labor code, education law, etc., heavy with anti-discrimination clauses. So this is the deep penetration of the anti-discrimination law regime in any national legal system. And it is also important to acknowledge at the outset that with these statutes, actually the regulation penetrates the private sphere or the sphere of civil rights, which is beyond the traditional concern of human rights and anti-discrimination law. So it's a much more privatized and horizontal regime than what human rights are usually used to. In the European setting, and this is my second point, you actually have a heavy layer of EC, or by now we call it EU law, on anti-discrimination. You have plenty of European legal instruments which the member states implemented, and the new member states were actually required to implement. The reason why I'm emphasizing this dimension is that in many of the post-communist countries, you actually do have a very advanced anti-discrimination regime in the law with numerous institutions, not only the constitutional courts and ordinary courts, but also specialized institutions which are meant to prevent discrimination. However, this very advanced stage of the legal system does not necessarily reflect a reduction of prejudice towards any particular vulnerable group. I hate to single out Poland, it's not nice of me, but it's very clear that the Polish struggle with anti-discrimination law, when you put it in context of a general animosity to LGBT rights, clearly shows that the fact that you finally implement the European anti-discrimination statute doesn't show any more of a wider or more intense acceptance for gay rights in Poland. So very often when you do just a comparative legal analysis, you will find that there is a legal regime in place, but especially in the European Union, there is a larger and larger distance between social values and what the legal system actually reflects. A third remark and partly a worry about anti-discrimination law is that over the years, it has become immensely technical and it has its own language. So it is possible that especially in the European regime, it's relatively easy to bring an anti-discrimination challenge before the national equality body. And it's also true that the burden of proof in line with EC law has been reversed. But actually, if you look at how the new instruments fit in the old regime, you will see that it takes quite a bit of thinking and figuring out which forum to go to and what kind of claim to bring. To bring an example from Hungary, which has all the protections I listed, plus an anti-discrimination statute and a special law on disability rights, you have three totally different types of litigation or processes in front of you, depending on which avenue you choose. And very often, courts and the equality body find themselves contradicting each other when it depends under the different regime, when they see the same claimant. And as a result, especially of the very generous accommodationist disability law, we have witnessed backlash too in the disability field. To give a very simple example, one commercial bank offered in their general terms of service that they will provide ATM machines for visually impaired people. This sounds all wonderful. Visually impaired and blind people go and open bank accounts with them only to figure out that they actually have 5 ATMs in one city, so not all the ATMs are usable for visually impaired people. And then you start to litigate, and once you have a very generous remedy against this bank, the outcome is not that the bank changes the machines. The outcome is the bank changes the contract and says that they are not blind-friendly anymore. So you can actually see that even with the widespread instruments and going for probably the most generous and most effective one produced a backlash in this particular instance, which is, I wouldn't say unique to Hungary, but this is the example which comes to me the easiest. So actually the plethora of instruments and does not necessarily mean that the level of protection overall increased, nor does it always result in conversation between the various bodies which are meant to implement them. A related problem, which goes to how anti-discrimination law is becoming more and more technical, is that anti-discrimination law and its particular subfields, such as disability law, managed to develop over time their very own terminology and language. So while disability people have a very good sense of what is reasonable accommodation, this is a term which doesn't travel across the various grounds, and it doesn't travel outside anti-discrimination law. And actually, to make the Americans very happy, reasonable accommodation in the disability field has nothing to do with what the Americans would call accommodation in the First Amendment context. So it's a very technical language, a very technical regime. And what you have a good sense of is that very often anti-discrimination law and the lawyers who do it become more and more involved with their own concepts and don't see outside the box. Another very good example is probably disparate impact litigation in the US. It seems to be a field of its own which has its own life, and it doesn't talk to civil rights litigation in general anymore. To mention yet another dimension of how specialized the field is and how easily one gets lost with a seemingly easy claim between the various institutions and various concepts. Let me give you another trivial example, and again it's coming from disability law in Hungary. We have a relatively easy target, which is actually a pretty clear-cut post-communist target. You want to get rid of big mental health care institutions. These are the institutions which house, depending on country, 300 to 500 people. They operate as hospitals, and they are the antithesis of anything that you would think about integrated living. You have a fantastic regime with all kinds of standards of proofs and, in general, facilitating litigation. The funny thing is that if your goal is not to tackle standards of care in one particular institution, but to get rid of the big institutions regime in particular, you have no one to turn to. If you bring disability claims in front of the equality body or in courts, you can only go against one institution who is mistreating claimants, and you can try to repeat this litigation against 50 or 30 or 60 institutions, depending on how eager you are. But you won't get the state on the other end. You will get the state in constitutional litigation, but then you only litigate on socioeconomic rights grounds anymore. So you won't get the remedy of actually the state getting rid of the big institutions. And so that shows you how the lack of interconnection between the various components of the regime actually disables and doesn't enable any type of attempt to tackle the systemic discrimination and disadvantage and prejudice. Another important layer, and I will also come back to this in the other panel because I find this extremely important, is that as anti-discrimination law moves predominantly being about race or ethnicity or gender, you very often see that the victims suffer from more than one type of discrimination at a time. This is what the discrimination lawyers would call multiple discrimination. the problem we've understood also in terms of intersectionality on the basis of the work of Kimberly Kershaw. But actually, what you see is that with the exception of linking gender and something else, so for instance gender and race, this is not taking you anywhere, because you are much more likely to win on one single strong ground than on multiple interconnected grounds in the discrimination setting. So with all this, and I'm trying to suggest that we made great advances in anti-discrimination law, no question about that. But as we are making these great advances, and as anti-discrimination law is advancing more and more, we are losing the connection with the other dimension of human rights claims, and as a result it becomes more and more difficult to actually tackle the underlying problems which create inequality in modern Western societies. So on the one hand, there is this fear of fragmentation already within discrimination law. On the other hand, there is a clear fear that the legal system, the more advanced it becomes, also becomes the more unable to protect against structural disadvantage. At the same time, it seems that with the fragmentation, with people specializing on one ground or in another ground, you will actually produce a system where experts in one or the other vulnerability or one or the other protected characteristics will generate some sort of clashes between essentialized absolutes. And of course the best example for that is religious discrimination versus gay rights, or freedom of religion and gay rights. Now to get to this particular problem, I will take a roundabout round, because I would like to draw your attention to a particular development which, as in the near future, will become particularly pressing. In a recent issue of Human Rights Quarterly, there was a long and very thought-provoking piece by Chapman and Carbonetti, who showed that although in the socioeconomic rights field in the UN, there is an emerging list of vulnerabilities to which the member states should pay attention to when they seek to, and I didn't say promote, but at least not violate socioeconomic rights. They actually have no sense of where the vulnerabilities come from, what makes one more attention-worthy than the other, and as a result, a list-based approach without a comprehensive theory undermines protection of substantive rights in general. In the ECHR regime in Europe, we thus far seemingly didn't have this problem, because the discrimination claims had to be brought together with a substantive rights claim. And so therefore you would have expected, at least as an outsider, that somehow the discrimination claims are more attuned to the substance of human rights violations and vice versa. Actually, what very often you see is that the discrimination angle is really very formally brought into the fundamental rights litigation in the ECHR. There are very, very few cases out there where the discrimination angle is actually heavily analyzed. For instance, the mental disability voting rights case, Alexandra versus Hungary, is a different one, or a refreshing exception, where the court actually explains why do they believe that mentally disabled people are especially vulnerable and are deserving the highest standard of scrutiny in the convention, but this is the exception. And so the result is that very often in the ECHR context, you receive strong protection for vulnerable minorities in less important passages in substantive rights cases. For instance, we always talk about how the ECHR is a champion of gay rights. Actually, the strongest ever passage comes from an assembly case, from Alexandra versus Russia, so this is not Baczkowski. where the court loses patience with the Russian regime and gay bashing in Russia, and in very strong terms. They speak about the accepted minimum standard, about how sexual orientation discrimination is a no-no, and gay people are not evil, but that's not worthy members of society, but this is not a discrimination case. And the real struggle is to get these two sentences from Alexandra to the LGBT cases, to bring me to the religion angle, and I'm aware of the time. Note that most of the religion cases in Europe are actually decided as a substantive rights case and not as a case of, not as an issue of religious discrimination. It sounds all fine and well until you actually want to protect religious minorities against a religious majority. And a good example in that, on point in that, is exactly the Gauci case in Italy, which can on the one hand be read as a case about the power of the state to regulate public education and teaching of religion, or the presence of religion in public education according to the traditions of the state. But another reading of this is, do we get to protect religious minorities against the wish of the majority in the public education sector, where actually the children are required to participate? This minority dimension, so the discrimination dimension, is completely missing in the ECHR freedom of religion jurisprudence at the moment, and where it shows up, it produced really awkward results. Now, when you get to the conflict of these two rights in the European regime, usually it comes up with an anti-discrimination law, and the way you see it is that it is pretty much communicated as the evil EU-required exemption of anti-discrimination law imposed on churches so that they couldn't discriminate so easily. And this is typically understood as an LGBT exception, although this is also protecting a number of other groups, including women. And very often, the way the essentialization works is that churches deserve church autonomy as an aspect of freedom of religion, and therefore these vulnerable minorities shouldn't come near. So this is presented as a clash of absolute religious autonomy of churches, stemming from freedom of religion on the one hand, and then a claim on behalf of discrimination law in discrimination law on behalf of vulnerable minorities on the other hand. But we are prone to forget that church autonomy is not beyond that. Actually, this is one of the most contested areas of freedom of religion as a human right. And we also seem to forget that even when legal regimes provide some protection to church autonomy, there is a serious level or a question of degree. So there's a difference between the state not interfering with appointing the highest church functionaries and church leadership for a country, as opposed to a church-operated school which receives public funding selecting between its students on the basis of sexual orientation. And if you sort of open up the box of church autonomy and have a sense of where it fits within human rights law, all of a sudden you realize that the clash of absolutes disappears, and actually the person you protect in this context is someone who suffers at least from two vulnerabilities, belonging to a sexual minority and is also being looked down upon within a religious community. And so this is what a regime which is not sensitive to the human rights dimension of anti-discrimination claims and the role of anti-discrimination law in the human rights regime is not going to be picked up. And so I'm urging anyone working and everyone working in anti-discrimination law to be mindful of the big project that is prejudice in society feeding into discrimination and not getting lost in the otherwise extremely wordy technicalities of anti-discrimination law itself. Thank you very much.
Dziękuję bardzo za wprowadzenie w problematykę prawa niedyskryminacyjnego. Przekazałbym głos teraz panu autorowi Jean-Pierre.
Okay. Good morning. Thanks for being here. I know it's a Saturday morning, so thanks again. I'm here representing the European Network Against Racism. I'll start with providing you with a brief introduction to what that is. It's actually one of the partners in this project, and we're very thankful for the opportunity to be here to present some of the work that ENAR has been doing on racism and religious discrimination in the European context. The European Network Against Racism is a network based in Brussels, but with national networks in 29 countries now. So all 27 EU member states and Croatia and Turkey have national sections, so to speak, of the network. Its primary role is working on European Union law and policy on anti-racism policy, but we also cover religious discrimination, mainly because of the lack of a network at a European level covering religious discrimination, and also the overlaps between race and religion as experienced by ethnic and religious minorities in Europe. I myself work for the People for Change Foundation, which is a consultant to ENAR, and what I'll be presenting today is research carried out by DFC for ENAR, which compiles European trends on racism and racial discrimination in Europe in 2009-2010. I'm just writing at the minute the 2010-2011 report, which hasn't yet been published, so I can't officially present it. But one thing that's for sure is that a lot of the findings remain the same, and that's one of the unfortunate realities, that year after year we'll have to present the same things. And I'm always scared that the people reading the reports are going to think I'm copying and pasting, but in reality it's a situation where the situation isn't really improving all that much. I'll start a bit by providing the basis for anti-racism in Europe. So, and then give you some figures and a brief outline of the legal framework, because that's already been covered. And then I'll cover the communities vulnerable to racism and some of the manifestations experienced in Europe with some general remarks. I have a habit of overshooting my time, so you're going to have to stop me. Yeah. Okay, so the basis for it all comes from the Universal Declaration, and I'm assuming we've all seen this, and this is at the heart of what ENAR is all about. Everyone is entitled to all the rights and freedoms set forth in this declaration without distinction of any kind, such as race, colour, sex, language, religion, political or other.
I'm sorry, you'll have to slow down.
Oh, yeah.
The point is that Polish is about a third, again, as well as English, so if you travel at the speed of light, these people here are going to understand about 50% of what you're saying.
Right.
You'll have to slow down.
Okay.
It's my human right.
Sorry about that. So anyway, this is the article from the Universal Declaration of Human Rights, which bases the work of ENAR. The legal framework in Europe is for European member states is obviously very intense, as she's highlighted. We've mentioned all of them already. So the most relevant in our context is the Race Equality Directive, which came through in 2004. Was transposed in most member states by 2007. Some countries had issues with it, so 2008, 2009. By 2010, most member states had transposed relatively adequately the Race Equality Directive. By transposed, I mean put into national law, not actually applied in practice in a way that is conducive to actually eliminating racism and racial discrimination in Europe. Some of the communities which we noted as being most vulnerable to racism in Europe, ethnic minorities, mainly Roma and African minorities. So by African minorities we include sub-Saharan Africans in Malta and Finland, for example, but also North Africans in Italy, for example. Religious minorities, most notably Muslims and Jews. But obviously, this year, where it's the first year that we have a report coming in from Turkey, we have other religious minorities that are being identified. So, for example, Christians have so far not really been identified, but obviously because we're now covering other countries, then that becomes an issue. Obviously, Turkey does not apply the Basic Policy Directive, so that's just to be clear. Status minorities, people with unstable migration status, migrants in general, both EU nationals and third country nationals, asylum seekers, refugees, undocumented migrants. And obviously this is something that my colleague has already mentioned. Multiple discrimination is a very big issue for ethnic and religious minorities in Europe, with the three that are highlighted the most being age, gender, and sexual orientation. So we have this, fancy statement in the Universal Declaration of Human Rights. We have a legal framework which is relatively strong, and yet we have a situation where 30% of ethnic minorities have faced discrimination in the last 12 months. The numbers, the statistics aren't actually in our zone. They come from a research carried out for the Fundamental Rights Agency, which basically interviewed something like 23,500 people from ethnic minority backgrounds across Europe. 30% of respondents had faced discrimination in the last 12 months. These numbers were much higher in countries like the Czech Republic, where 64% of Roma respondents had faced discrimination, 63% of Africans in Malta, and 62% of the Roma community in Hungary. This is basically the number of instances of discrimination reported in countries per 100 respondents. So in Italy, the North African community in Italy reported 929 incidents of racism and racial discrimination in a 12-month period, so in a 1-year period. So for every 100 respondents, so what we're saying is that we have more than 9 incidents per respondent in one given year. On average, it was 207. So on average, a member of an ethnic minority in Europe faces 2 racist incidents in any given year. These are some statistics, again, regarding looking for work. Obviously, employment is one of the key areas where discrimination is faced. This is specifically when looking for employment and not looking at discrimination within employment, although the EU with this research does actually cover that, and I do encourage you to have a look at that research, because it does give some shocking indications of what Europe really is all about. 90% of Roma across Europe, of the Roma respondents to the research, said they face discrimination when looking for work. 87% of sub-Saharan Africans and 92% of North Africans, 97% of Central and Eastern Europeans said they faced that sort of discrimination. They faced discrimination, but they also did not report the discrimination that they faced when looking for work. Sorry, that's my mistake. Basically, this is another very big problem that we have in Europe, and I'll get to it later. Ethnic minorities do not feel that reporting cases of discrimination is going to get them anywhere, and they're not reporting those cases. So we have a legal framework. In most countries, we have the institutional framework that's supposedly there to apply it, but ethnic minorities do not feel that that institutional framework and that legal framework is actually beneficial to them. They do not feel that they will get anything out of reporting cases of discrimination. This is, again, regarding cases of discrimination which were reported. So you see the white parts are the cases that were actually reported, with the black parts being the cases that weren't reported. And this is an overall rate, so it's not in one specific sphere of where discrimination occurred, but the general across the spheres. This is an interesting graph, also coming from one of the focus reports that came out from the EU with this research, and it compares the perceptions of discrimination as described by the majority population as referred to in the Eurobarometer surveys, and the findings from ethnic minorities. It's interesting to know that in most cases, the perception of discrimination as being widespread is what is higher in the case of the Eurobarometer. So the majority population is aware of discrimination happening. and is more likely to think that it is fairly widespread or very widespread than the minorities facing it. Obviously, this is an average across Europe, and you have very clear distinctions between, for example, Sweden, where the majority population said it's much wider than the minority population said, as opposed to Poland, where the findings were that the minority populations were, adamant that it's very, very widespread, was the majority population were kind of more reluctant to say that, let's put it that way. This is another indication regarding non-reporting, and this is a point that I'd really like to stress, the fact that people are not reporting and the importance of reporting. And with that comes the importance of increasing awareness of the legal framework, increasing awareness of the remedies available, but also making sure that the remedies we have are actually effective. Having a remedy in the law, having an equality body which is entirely useless, where a member of an ethnic minority goes and has to wait for 2 or 3 years to get an answer, which is basically saying, oh yeah, you were right, but we can't really do anything about it. That is simply not good enough. And ethnic minorities do not have the time to waste in using channels which are going to be effective. This is the case of reporting to the police in the case of racist violence and crime. And the reasons why people aren't reporting such cases. And it's interesting to know that almost 50% of those who didn't report cases of assault and serious harassment to the police said they didn't do so because they were not confident that the police would be able to do anything about it. Others were too afraid to report it or dealt with the problems themselves by discussing it with friends and family, which again is not the remedy that we would normally go for in the case of violence and in the case of serious harassment and assault. There's a couple of overarching issues that come out from the different manifestations of racial discrimination in Europe. The first one is the impact of the global economic crisis, and linked to that is the commodification of migrants. And by that I mean, in Europe we are looking at migrants no longer as human beings who are subject to rights, but we are looking at them as economic units. They are not there and have the human rights that we guarantee to our citizens. They are simply there because our economy needs them. They are simply there to produce the goods that our economy needs. This obviously has clear implications in how we respect their rights, but also how we perceive their role in a time of an economic crisis, where it is much easier to draw the line and say, okay, you're out and you're in, because they are simply economic units. For all Europe cares, they could be essentially machines, because that's their role. Another issue is the fact that in a lot of countries we're failing to acknowledge that racism and racial discrimination, as well as religious discrimination, is a real issue that needs to be addressed. I have 3 minutes. Okay. And that's problematic because the first, I'm sure there's a quote that says something on these lines. The first step to solving a problem is admitting to it, right? And unfortunately, most member states and to some degree the European institutions aren't doing that. And resulting from this is the issue of data collection. We do not have sufficient data as to the extent of racism and racial discrimination in Europe. The EU Midas report, which only came out in 2009-2010, is the first systematic collection of that sort of data. Most member states do not have indicators of employment rates by ethnic minorities, race-segregated data on housing and education, educational attainment, etc. If we do not have that information, then how are we going to plan policies? How are we going to arrange for those policies and initiatives to be implemented? And more specifically, how are we going to evaluate whether the policies that we seem to think are going to work so very well for ethnic minorities in Europe are actually working or not? Another issue is, I've mentioned this already, implementation of legislation and its enforcement in Europe. The Race Equality Directive has, technically speaking, been transposed. The situation has already been mentioned with multiple discrimination. Religious minorities continue to be not protected by the European anti-discrimination framework, except within the context of employment. so in housing, education, etc. There is the horizontal directive, which is currently coming through the channels of the EU. It seems to be taking so very long, and that reflects the fact that the European member states do not really want to go down that line. The European Commission is kind of intent on getting it there, but member states are clearly holding their horses on it. I've already mentioned issues of investigations and reports of incidents of racist crime. With regards to investigation, one of the issues is that you have ethnic minorities going to police stations, and this is not only in cases of discrimination, but in cases of actual violence, and the police not taking them seriously, or just not doing anything with the investigation not going anywhere. Another issue is the rise in far-right politics in Europe, and one of the points to be made on that is that we have a degree of extremism in Europe, which is making things that would otherwise seem unacceptable be considered acceptable because there's someone who is far more extreme. And we're okay with saying that the person on the extreme is wrong to be so extreme, but then the person who is halfway there, he's not seen as that extreme in what he's saying, which would, had that extremism not been in the context, being considered as unacceptable, suddenly becomes unacceptable. And the other thing is interrelations between different areas of discrimination. So if I'm not working, if I'm facing discrimination and accessing the labour market, it is going to be very difficult for me to find housing in an affluent area of town, which means I'm going to be in a remote part where the schools aren't that brilliant, which means that my kids aren't going to get the educational standards that they might deserve or they might be able to attain, which means that they're going to have problems getting the education that they deserve and the jobs that they would otherwise get. And it's all a vicious circle, so there's various interrelations between different spheres where discrimination is occurring. I have a couple of areas which I wanted to cover, but I don't have time, so more than happy to answer any questions.
Dziękuję bardzo. I teraz zmienimy perspektywy trochę i przeniesiemy się do Ameryki i posłuchamy o problemach, które tam występują, jeśli chodzi o równość.
Thank you very much for having me again. I'm very happy to be in this panel and in this very equally gender panel, no? We did it, and thank you for the organizers for that. I like to start saying, or remembering at least, that I share many of the views that both speakers said, and of course I will concentrate on Latin America and our own problems. Now, maybe we don't have that much this religious discrimination, but of course we do share some of the problems, and we have other by our own. I think we have to start. I wanted to start by remembering that Latin America, even though it's very diverse, it's in culture, in ethnicity, in music, in dances, in food, and everything, and composed of many millions and hundreds of millions of Afro-descendants, indigenous peoples, and so on, it's still the most problematic region in the world when it comes to an equal distribution of wealth. Now, UNDP has been mentioned one and again that out of the 15 more unequal countries in the world, 10 of those countries are in the Americas, which is of course not good. And this, I think, is not a surprise. It's not a surprise. It's not that happened yesterday, but it explains also with our own history. No? As I mentioned yesterday, in many of our countries, we had internal armed conflicts or very lack of democratic authorities or regimes, and many of them were solved in peace accords. And in those peace accords, I want to speak specifically about Guatemala, but we can of course talk a bit about many of them. In those peace accords, both the parties agreed that there had to be, for example, urgent land reforms, no? A guarantee of basic human rights such as education or health, tax reforms, guaranteeing that really the richest pay their own part, and of course a better in itself distribution of wealth. No, this hasn't happened. We still are waiting for tax reforms in many of our countries, and so on. That's one way, a very simple way of saying, of explaining this exclusion for many Latin Americans in our continents. Now, discrimination, as in Europe, has been included in many Latin American penal codes, legislation. We have both all the institutions and specialized institutions that have to prevent discrimination or tackle discrimination both by individuals and public officials, no? But that doesn't impede that we have many cases of hate crimes, no, in the Caribbean, but also in Latin America. We have many examples of restrictions for persons to going into public places, for example, bars or restaurants, specifically, for example, for those that are brown, no, that are more indigenous, and that therefore that they don't belong in certain public places, or of course restriction for education to indigenous or disabled peoples. No, discrimination of course is very structural. It's hidden and showing every facet and everywhere. And in those cases and in those structural situations, many countries have been unable to prevent and tackle discrimination. Therefore, many cases have gone to the Inter-American system, which is not, which has proven to be effective in so many ways. But of course, there's still many things that the system has to do, and I will focus specifically on some cases. Now, we have many non-discrimination clauses, as it has been mentioned. Either by general obligations in the American Declaration on the Rights and Duties of Men, and both the American Convention on Human Rights and the optional protocol to this convention regarding economic, social, and cultural rights, which is called also, or known also as San Salvador Protocol. We have specific rights in that protocol, as well as in an Inter-American Convention on the elimination of all forms of discrimination against people with disabilities. And we, of course, have a convention on the prevention, punishment, and eradication of violence against women, also known as the Belém do Pará Convention. No? What the Inter-American system is trying to deal with all these problems in several ways. No? The Commission, I'll start with the Commission very briefly. The Commission has different rapporteurships, just as the UN has, and it is very interesting to see that the Commission, all the rapporteurships that have been created by the Commission, but one, deal with specific groups or sectors. No? There's just one dealing with freedom of expression, but the other ones deal with, or are in charge of, have the mandate of children's rights, women's rights, Afro-descendants, indigenous peoples, migrant workers and their families, human rights defenders, imprisoned persons, and most recently there's a specific area dealing with LGBT's rights. The Commission has also drafted several reports recommending states to take different steps to tackle discrimination and to move towards substantive equality, both of women but also children and indigenous. These publications deal with political participation of women in the Americas, maternal health services from a human rights perspective, access to justice for women, victims of violence in the Americas, and the Commission has also drafted specific reports or country reports regarding women's rights in Bolivia, Guatemala, Paraguay, Peru, Colombia, the Dominican Republic, so on. No? The Commission has also drafted specifically reports on some of the issues that are more disturbing regarding the rights of women. Equality in the family, labor, and political spheres in Chile, and of course, right to women to be free from violence and discrimination in Haiti, but in Mexico as well. As you know, in Mexico, in the northern states in Mexico, there have been, since the late 1990s, many murders and disappearances of women. There's one case that I will refer by the court, but the Commission started to focusing on this situation and saying that the state, Mexican state, not only had to take all the necessary steps to prevent that violence against women, but also to investigate that violence, no? And to investigate those causes, because it was very typical to see that in these more than 400 cases of disappeared women and women killed, it was very easy to see that the public prosecutors always tend to blame women or their families, no? Because maybe they were in a certain place that they didn't have to be, maybe they were wearing some clothes that they weren't supposed to wear, and that's why they, after all, were disappeared. I mean, it was their own fault that they deserved that treatment because of what they were doing, no? As you can see, that the Commission has done many things regarding women's rights, but also there have been some interesting developments around other vulnerable or groups in a vulnerable situation. The court has said, of course, that non-discrimination is, regarding non-discrimination, states have both positive and negative obligations. The court has also ruled that the non-discrimination clause is a jus cogens guarantee. The court has also said that there has to be some states have to bear in mind certain particular situations regarding the populations or the victims that we try to attend. So, for example, regarding mental disabilities, disability persons in private facilities and the obligation to the state to supervise those facilities, or regarding street children or social cleansing of poor young persons in Honduras, the court has said that the states have to take into account special circumstances of those persons. No, the court has also dealt with statelessness of Dominican girls from Haitian descent, ruling that the obstacles imposed by Dominican authorities in order to get their birth certificate and therefore their nationality were racist practices and had to be derogated. And in the case of Violeta Hocico, the court also ruled on the effects that the lack of a birth certificate had in her education. She dropped school and had to study at night with adults in very insecure circumstances. The court has also dealt with imprisoned indigenous and mistreatment imposed, taking advantages of their circumstances. For example, in an indigenous case in Honduras, the mistreatment was regarding the food or the language. I mean, taking the advantages specifically of an indigenous person. Of course, the court has ruled on displaced persons and discriminatory practices in Colombia, but also the court has ruled a lot about ancestral indigenous territories, specifically in Paraguay and Nicaragua, the political rights and exclusion of indigenous people for participating in elections. The court ruled that imposing the same requirement to indigenous political parties violated Article 23 of the Convention on Political Rights, as well as Article 24, which is the non-discrimination clause. And the court, I want to end with this example because it deals with multiple discrimination. The court has ruled in 2 cases against Mexico regarding indigenous people that were raped by the military. No? In these cases, Valentina Rosendo Cantú was 17 years old when she was raped by the military in Mexico, by soldiers in Mexico, and Inés Fernández was 25. In both cases are examples of the exclusion of many services that and rights that indigenous poor populations and women as well have to deal with. The commission argued before the court that this was a multiple discrimination case. The court didn't rule as such. But it took into account the specific context of exclusion of indigenous people in Guerrero, in Mexico, and specifically the court says that indigenous population is in a situation of vulnerability, and this is reflected in various forums, such as in the administration of justice and healthcare services. Especially the members of this population are defenseless because they don't speak Spanish and don't have interpreters because of the absence of financial resources to hire a lawyer, to travel to healthcare centers or to the organs of justice, and also because they're often victims of abusive practices or practices that violate due process. Owing to this situation, the court says, members of the indigenous communities do not use organs of justice or the public agencies engaged in the protection of human rights because they distrust them or because they fear reprisals. And in the case of indigenous women, the situation is even worse because filing complaints concerning certain acts has become a challenge that requires them to overcome many obstacles, such as rejection from the community and other harmful traditional practices. The court then ruled about all the due diligence in the investigation that the state has to do in order to repair these cases, and specifically the court also deal with the exclusion of all the children in the community by both the health services but also the education services. And the court in its reparations part of the judgment ordered the state to adopt measures so that the girls in the community of Inés Fernández, Barracatecuani, carry out their own middle school studies in the city of Ayutla, may provide that offer adequate food and shelter so as to allow the girls to continue their education at the institutions which they attend. This happened because in many places in Latin America, domestic labor is in many ways seen and treated as slave labor. No? We have different cases pending on indigenous consultation, discrimination against LGBT, mosquito divers. More than 4,000 mosquito divers have physical disability because state do not prevent or do not supervise how they dive in order to look for lobsters and sell them. We have pending cases on HIV/AIDS and so on. I think that there are many challenges regarding both the court's jurisprudence, the cases that are before the commission and the court, the lack of documentation of cases, other actors that are staying to play a key role before the Commission. For example, mining corporations, lawyers are attending hearings before the Inter-American Commission on Human Rights. Many cases deal specifically with individual, rather collective rights, and of course the challenge of the number of victims. But I think that both the Inter-American system has proven to deal with some aspects and some problems, but since discrimination and exclusion is such a huge problem in Latin America, at least, it is indispensable that states really take their own parts so that they tackle discrimination within their own jurisdiction, because otherwise, I mean, we can have a very interesting developing Inter-American system, but it will be just not enough to tackle this huge problem in Latin America. Thank you.
Dziękuję bardzo. Ja bym chciał się w swoim wystąpieniu skupić na kategorii, o której wspominał Jean-Pierre, mianowicie o migrantach. I postawiłem taką tezę, że Okej. Jakiś problem mamy z tłumaczeniem? Więc chciałem postawić taką tezę, że w społeczeństwach rozwiniętych, północnych, mówiąc bardzo szeroko, bym bardziej chciał mówić o kwestiach związanych z społeczeństwami Unii Europejskiej. Stosujemy podwójne standardy wobec osób, które mają, wobec naszych obywateli i wobec migrantów, którzy do nas przyjeżdżają. I to nie chodzi nawet o kwestię, w moim przekonaniu, równości czy nierówności, tylko o kompletnie inny zestaw standardów, które używamy i które stosujemy wobec tych ludzi, których prawdopodobnie nigdy byśmy się nie odważyli jako społeczeństwa zaimplementować, zastosować wobec naszych obywateli. Tutaj już Jean-Pierre mówił wcześniej o tym, że migranci są postrzegani w Europie obecnie jako tania siła robocza. Mimo tego, że w latach 90. jeden z kanclerzy niemieckich, mówiąc o problemie migrantów, powiadał, iż spodziewali się siły roboczej, a przyjechali ludzie, to cały czas w zasadzie postrzegamy się jak siłę roboczą i nie zauważamy tego, że to są którzy mają określone prawa, powinni mieć, powinniśmy je zagwarantować tym osobom. Oczekujemy, że przyjadą do Europy, zrobią swoje i wrócą do państwa pochodzenia, z tym nie zamierzamy nawet gwarantować jakichkolwiek praw w sferze społecznej, tak żeby myśląc w perspektywie mogli się w Europie osiedlić, założyć rodzinę i tutaj zostać. Mimo tego, że oczekujemy, że większość swojego życia przepracują dla nas, a potem wrócą do siebie, nie wiadomo z czego będą żyli, ale to tak naprawdę niespecjalnie nas już w tym momencie interesuje. W stowarzyszeniu, w którym pracuję, prowadziliśmy niedawno, właśnie teraz zakończyliśmy badania nad tym, jak są przestrzegane prawa pracowników migrantów w Polsce, w polskich pracodawców. Badaliśmy pracowników nisko wykwalifikowanych. Oczywiście nie jest zaskoczeniem, że prawa nie są przestrzegane, natomiast to, co jest zaskoczeniem, to to, że cały system prawny jest skonstruowany w taki sposób, by nie dopuścić do egzekucji, skutecznej egzekucji naruszeń praw pracowniczych przez migrantów. Mówię tu o kilku elementach, o tym, że mamy w Polsce związany system legalizacji pobytu z prawem do pracy. W związku z tym, jeżeli ktoś traci pracę, automatycznie traci prawo do legalnego pobytu w Polsce, w związku z tym jest wydalany. W związku z tym nie jest w stanie nijak się sprzeciwić własnemu pracodawcy, wystąpić przeciwko niemu wobec władz sądowych, władz publicznych z wnioskiem o naruszenie jego praw, ponieważ będzie w tym momencie pozbawiony pracy, pozbawiony prawa do zostania w Polsce i wydalony. Sprawa nie ma jak się zakończyć w sądzie. Z drugiej strony, kiedy patrzymy na działalność służb publicznych i inspekcji pracy, to się okazuje, że one również, mimo tego są powołane do ochrony pracowników, to są powołane do ochrony pracowników polskich, ponieważ w momencie, gdy inspekcja kontroluje zakład pracy, znajdzie tam osobę, która pracuje bez właściwych dokumentów, to we Strażą Graniczną doprowadzi do wydalenia tej osoby z Polski. Natomiast pracodawca oczywiście poniesie pewne konsekwencje w postaci grzywny najczęściej. Natomiast pracownik, nie dość tego, że nie dojdzie, nie otrzyma może nie otrzyma praw, nie otrzyma zadośćuczynienia za złamane prawa, to jeszcze będzie wydalony z terytorium Polski z zakazem wjazdu do Unii Europejskiej, ponieważ naruszył przepisy o legalnym zatrudnieniu. I teraz powstaje pytanie, gdzie tu jest problem? Znaczy, czy to jest tak, że to, jak często się mówi, mamy migrantów, którzy przybywają do Europy wielką falą i ich marzeniem jest praca w szarej strefie, czy też to cały system, który stworzyliśmy i który akceptujemy, zmusza migrantów do tego, żeby w tej szarej strefie pracowali, przebywali. Bo jeżeli popatrzymy znowu na polski przypadek, to wydaje się, że akceptacja pracy bez umowy jest powszechna w całym społeczeństwie. Wielu Polaków tak pracuje, tylko o ile Polacy nie ponoszą przynajmniej w tak wielkim stopniu negatywnych konsekwencji, choć ponoszą je również, to migranci ponoszą je w bardzo wielkim stopniu, ponieważ bez pracy legalnej nie mogą się w Polsce czy w innych państwach Unii Europejskiej zalegalizować i być tutaj, korzystać z praw, które przysługują. W związku z tym są zmuszeni do tego, żeby pozostawać w sytuacji nieudokumentowania, żeby stać się migrantami nieudokumentowanymi. Czyli są nam potrzebni, żeby napędzać gospodarkę, szczególnie w kryzysie, bo są tanią siłą roboczą, natomiast w żadnym razie nie mamy ochoty, żeby zostali tutaj w naszym kraju legalni. Co w związku z tym, kiedy są nieudokumentowani, kiedy stają się do szarej strefy? Są niewidoczni, są niewidoczni dla społeczeństwa, są niewidoczni dla władz. Władze starają się nie widzieć problemu i nie przeciwdziałać mu. Jedynym przeciwdziałaniem tak zwanemu problemowi jest ściganie nielegalnej migracji i nieudokumentowanych migrantów i karanie tychże. Dyrektywa, która obowiązuje obecnie w Unii o przeciwdziałaniu nielegalnemu zatrudnieniu, w zasadzie w niewielkim stopniu przeciwdziała podstawą tej sytuacji, bardziej ślizga się po powierzchni i stara się karać, bo tak naprawdę do tego się sprowadza, karać przede wszystkim migrantów, chociaż również w jakimś stopniu pracodawców. Skutkiem nieudokumentowania, jeżeli migrant zostanie zidentyfikowany jako nieudokumentowany, jest detencja i zamknięcie takiej osoby w areszcie. I znowu, przecież sam fakt bycia nieudokumentowanym migrantem nie jest przestępstwem w żadnym z państw Unii Europejskiej. Tym niemniej stosujemy wobec migrantów sankcje karne. Zamykamy ich w placówkach, które są takie same w zasadzie jak miejsca pozbawienia wolności, jak więzienia. A co jest zupełnym paradoksem w Polsce, często placówki dla cudzoziemców detencyjne mają warunki znacznie surowsze niż niektóre więzienia. A imigranci, którzy tam przebywają, mimo tego, że powtórzę jeszcze raz, nie popełnili żadnego przestępstwa na terytorium Unii Europejskiej, są w warunkach znacznie gorszych niż osoby, które popełniły czyn zabroniony i w związku z tym zostały za ten czyn ukarane. Środki detencyjne to jest kolejny paradoks, stosuje się nie tylko stosuje się także wobec dzieci. Jest to znowu jedyny przypadek, kiedy państwa Unii Europejskiej pozwalają sobie bez żadnego problemu na zastosowanie kary pozbawienia wolności wobec dzieci, niezależnie od ich wieku. Dzieci są przetrzymywane w takich samych warunkach jak dorośli. Dzieci są również reżim, któremu są poddane, jest taki sam jak osobom dorosłym. W związku z tym mają prawo do godziny spaceru dziennie, w zasadzie dostęp ich do edukacji jest bardzo mocno ograniczony. W Polsce w ośrodkach, w których przebywają, mają spotkania od roku z nauczycielami w niektórych ośrodkach, natomiast to nie ma nic wspólnego z dostępem do edukacji jako takiej. Tym niemniej znowu nie widzimy specjalnego problemu, żeby taką sytuację akceptować. W detencji umieszczamy również osoby, które starają się nadać status uchodźcy i wjechały do Europy nielegalnie, bez dokumentów. Większość migrantów, którzy uciekają przed prześladowaniami, wjedzie na terytorium Unii bez wymagania dokumentów. Spotkali za to osadzenie w więzieniu. I znowu dochodzimy do sytuacji, kiedy karzemy karą pozbawienia wolności, czy stosujemy takie same środki kary pozbawienia wolności wobec ofiar przestępstw de facto. Przypadek bardzo świeży z wczoraj. Można powiedzieć, mieliśmy, bo nie wszystkie te osoby przebywają dalej w Polsce. Kobiety z Kenii, które padły w tym państwie ofiarą gwałtu, Witoldu na tle seksualnym, trafiły do Polski i sprawa azylowa została zakończona decyzją odmowną. Jedna z pań decyzję dostała ostateczną wczoraj o godzinie 15. O godzinie 12 w nocy już była w drodze na lotnisko w Warszawie. Obecnie jest do Frankfurtu i do Kenii. Żadne skutki, żadne przepisy nie uchroniły tej pani przed deportacją. Polskie przepisy są kompletnie niewydolne w tym zakresie, ponieważ nie wstrzymują wydalenia. Można wystąpić do sądu z zakazem wstrzymania wykonalności decyzji, ale trwa to około 2 miesięcy. Wysłaliśmy wczoraj interimerze do Strasburga. Strasburg zajmie się nim w poniedziałek. Tej pani nie będzie już na terytorium Unii Europejskiej i nie wróci zapewne z powrotem do nas. Drugiej pani się poszczęściło. Ta pani akurat jest naszą klientką. Decyzja nie została jej doręczona właściwie, w żadnym stopniu. Została deportowana tylko dlatego, że zabrakło miejsc w samolocie. Więc rzeczywiście może w momencie, gdy Strasburg rozpatrzy sprawę w poniedziałek, to będzie miała szansę w Europie zostać. Natomiast to jest tylko i wyłącznie kwestia szczęścia, że zabrakło miejsc w samolocie. Stąd procedury, które stwarzamy w Europie, są skuteczne wobec obywateli Unii Europejskiej i ich zabezpieczają. Natomiast nawet jeżeli formalnie te procedury są stworzone, to się okazuje, że w praktyce wobec migrantów one nie działają. I to nie jest, wydaje mi się, kwestia przypadku, że te procedury są tak zaprojektowane, bo przecież to nie jest... Mówimy o tym niejednokrotnie, że taka sytuacja wygląda, tym niemniej nikogo nie ma ochoty jej poprawić. Bo jak w zasadzie Europa jest, prawda, znowu staje się coraz bardziej twierdzą oblężoną, jak twierdzą niektórzy, przez napływ cudzoziemców. To, co się staramy robić, to zabronić naszego terytorium, jak tylko jest to możliwe. Wprowadzamy procedury, które pod płaszczykiem praw człowieka ich celem jest nierozpoznanie cudzoziemca jako osoby potrzebującej ochrony na terytorium Unii Europejskiej. Cała procedura azylowa w zasadzie zaprojektowana w taki sposób, żeby wytknąć najdrobniejsze błędy w zeznaniach danej osoby, co skutkuje wydaleniem jej i nieprzyznaniem jakiejkolwiek ochrony na terytorium Unii Europejskiej. Nowe przepisy, które budujemy w Unii Europejskiej pod pojęciem ujednolicania systemu azylowego, w zasadzie prowadzą do tego, żebyśmy ten system bardzo mocno zaostrzyli i w jeszcze mniejszym stopniu zaoferowali cudzoziemcom, którzy do nas przybywają, ochronę na terytorium Polski, czy terytorium Unii Europejskiej. Jest znakomity raport Fleeing Homofobia, który się nazywa, robiony przez koalicję różnych królewskich instytucji, włącznie na czele z Wolnym Uniwersytetem w Amsterdamie, który pokazuje ewolucję, w niektórych państwach ewolucję ochrony osób LGBTI przed prześladowaniami i ochronę, jaką mogą znaleźć, o ile mogą znaleźć na terytorium różnych państw Unii Europejskiej, pokazujący bardzo krótką drogę, po pierwsze, tego procesu, a po drugie pokazujący, że stoimy zupełnie niestandardy. Walczymy o prawa osób LGBT w Europie dla naszych obywateli. W momencie, gdy ktoś przyjedzie z zewnątrz, to co sądy proponują, żeby wrócił do siebie i żył w ukryciu, po cichu, żeby nikt się nie dowiedział. Wtedy oczywiście żadna krzywda mu się nie stanie. W związku z tym nie będzie potrzebował ochrony w państwach Unii Europejskiej. Czyli reasumując, wydaje mi się, że wobec migrantów, którzy przebywają na terytorium Unii Europejskiej, nie możemy mówić o naruszeniu równego traktowania, tylko możemy mówić o stosowaniu dwóch zupełnie innych rodzajów standardów ochrony do tych osób. I to jest oczywiście w moim przekonaniu tylko i wyłącznie polityczna wola włodarzy naszych państw i włodarzy całej Unii, którzy w taki, a nie inny sposób projektują te systemy, żeby jak najmniej migrantów, nie to, żeby się jak najmniej migrantów dostało do Unii Europejskiej, ale żeby przylecieć, których chcemy, na czas, który chcemy, a potem, żebyśmy mogli spokojnie się ich pozbyć, kiedy przestaną być nam potrzebni. Dziękuję bardzo. Mamy teraz jeszcze 25 minut na dyskusję, na pytania. To jest czas dla Państwa, w związku z tym zachęcam do zadawania pytań, do komentarzy. Proszę, żeby tylko po pierwsze o jeden mikrofonu, który nie wiem, czy się dzieje zaraz, ktoś z mikrofonem pojawi. Jest, dobrze. I o przedstawienie się. Bardzo proszę. Jest.
Lord Lockwood, thank you very much for interesting, your Cincinnati, interesting presentations. There was one thing that was sort of said as an aside, and I realize that it's not directly on point, but I'm sort of intrigued as to whether there is either a legal basis in the inter-American system or the European system. Is Alexandra, I heard you say, I believe that there were some maybe peace settlements, recommendations from peace settlements that were talking about tax reform. I'm curious whether there is any basis for an argument in either system or cases relating to it that a state is obligated to either have a progressive form of taxation or, I guess, in any way that it sort of affects the tax system that a country adopts.
I think okay. So is the next question?
Yes. My name is Sunva Montrem. I'm from the Rafter Foundation in Norway. I am quite concerned and always a bit surprised and worried about how us and them dichotomies and images also function on a structural level. You have shown several examples of this during your presentations that were really good, I think. And in Norway, we also have these us and them dichotomies on a structural level. For instance, single minor asylum seekers from the age of 15 to 18 are not under the protection of child protection services. And that would never happen if that was Norwegian children. So they live under quite different circumstances than the rest of the children in Norway that are also under child protection services. And normally I believe in the legal system to be a good way to change attitudes. But I also heard that Professor Renata Uitz said that there was no correspondence between the legal system and prejudices. For instance, in Norway also, there was a smoking law, quite another field, but there was a smoke and tobacco law that really changed attitudes towards smoking and tobacco for just a few years. Just for like 1 year or two, everybody had, many people had different views on this. So I believe that the legal system can be an effective tool in changing attitudes. But under what circumstances can it be? And how could we also be a step ahead of the legal system? How can we make the legal system reflect the human rights more, and how can we change attitudes with the legal system?
I just ask a quick question. Put a question for Jean-Pierre, and I may have missed this, but I'm curious if you have any kind of assessment with respect to the work of what I believe is a fairly new agency, the Agency for Fundamental Rights under the EU, that is headed up by Morten, I'm never sure how to pronounce the last name, Kajon, who used to be the head of the Danish Human Rights Center. And I think this is one of the areas that they are focusing on, and I'm just curious if
in Guatemala, I take the Guatemalan example, but we can talk about other examples as well. Guatemala suffered 36 years of war, no? Since 1960 till 1996, when it formally ended with the peace accords. And in those peace accords, they knew that not only the Mayan population was subjected to all kinds of racism. I mean, in less than 2 years, there were 626 massacres against just the Mayan population. No? But they knew that the very essence, structural essence of this conflict was the unequal distribution of wealth, no? So that was a very strong way to say, well, in the peace accords we have to have not only different many things, but specifically we know that the rich are not paying and the rich are not doing their part, no? And that was pretty much the base of the conflict. So that's why they took this peace accord. In Guatemala, the situation is still the same. Every single year, when it comes to discuss the budget before the Congress, there is no, I mean, they tackle the idea of a tax reform, no? And how do you say, when you don't pay taxes, evasión fiscal, is really bad. It's really bad in our countries, and it's not that everybody don't pay taxes. It's that the rich don't pay taxes, no? Because usually those in the middle class or the poorest pay their taxes, no? So in the inter-American system, these specifically tax reforms haven't been taken into account, but I think the consequences of those lack of structural measures are the reasons that many cases go to the system. Land reform is something that is really growing in the Commission. No, not only that in the last decades they had to give land to all people, but specifically when it comes to ancestral or important territories, when oil companies or mining companies have specific interests. No, the Commission and the Court, yes, have ruled that the state has to give resources both to education, to health, to the judicial system, and so on. No? But I think that these struggles for land and for other wealth are having really negative consequences. Criminalization of leaders or human rights defenders or even indigenous leaders. For example, in Chile, there is this case pending before the court of an indigenous leader that was fighting against for their territories, and it was the only case that in Chile they applied the terrorist legislation, no, Ancalaf. So I think that many of those consequences are starting to go to the system.
Okay, so to Brett Lockwood's question, the peace accord problem obviously is not very relevant in Eastern Europe, but what you actually see, and this is important, is that part of transitional justice measures did affect property and property redistribution, whether through privatization or restitution in most of Central Eastern Europe. And now there is a thickening layer of ECHR jurisprudence on it. So in addition to the constitutional court jurisprudence, it does make good sense to look at those cases, partly because the ECHR doesn't care for the transitional justice exception and doesn't care for the exceptional nature of these solutions. There is an edited collection by Michael Hamilton and Anton Boyce on the transitional justice jurisprudence of the ECHR, which is interesting here. From the ECHR, you in general have very little on taxation and a tax regime as a whole. The closest you come to the unjust redistributive impact is the various adjustments made to pensions, but that comes so as individual petitions, and that would usually come in property cases. So actually, this systemic again a systemic challenge is extremely difficult to mount, and I think we are eagerly waiting all the IMF, EU. Conditions on tax reform with many of the country bailouts, but those are, there you have very few human rights concerns. I mean, as to the legal systems and social change point, I didn't say that legal change has nothing to do with social change. I said that in this particular realm of anti-discrimination law, in the post-communist countries, you have a very robust formal legal regime which does not correspond to changing values in those societies where these instruments were adopted. So on the one hand you have a strong legal regime, but the values of these societies are not meeting the values which you would assume underscore this legal regime. And it's a really awkward game where local players, if they introduce or transpose anti-discrimination measures at all, if they don't wait for it forever, they still relativize it, saying that this is EU imposed and we have nothing to do with it, so we will choose the weakest option. And it's easy to demonize the protected minorities, to say that, of course, these are the enemies, these are the others, and well, EU, the enemy, or those others, so it's the EU is the others together with the excluded groups. So we sort of need to defend our national values against them. So this level of EU insistence on some of the anti-discrimination measures actually triggers an unwanted result and feeds into traditional discourses of stereotyping, which is a serious problem. And this is the point where an Europe-friendly gay community is actually the enemy of the nation. And this is definitely something you didn't want. Of course, there is varying intensities in the various member states, but if you don't take it into account, it's very difficult to explain. For instance, as in Hungary, you have I don't know if it will stay in force and for how long, but currently we have a very robust civil partnership regime, and every single year, irrespective of this law, if we have a gay parade, then it is going to be beaten up by right-wing extremists, and the government will be unlikely to be very enthusiastic about defending it. They will defend it, but they will not be showing this is totally unacceptable, what you are doing here. They will be simply trying to suggest that, well, these awkward things anyway, it will go away, don't worry. And that's a very different kind of governmental attitude. So I would suggest when you look at socialist change that very often you have organic and gradual transformation. And for instance, in the LGBT literature, the current American narrative with Martha Nussbaum, Kenji Yoshino and others emphasizes that we reach this age of a dignity, of proper inclusion in society. And I made an argument mostly on Eastern Europe that we are not there yet. If we are lucky, we manage to block veto players. And EU law can be used for that. But that's, even if the outcome is the same, that is, we have a partnership law at the end of the tunnel, it doesn't mean that we got there with this organic change where societal attitudes were deeply turned over in favor of rights of disliked minorities.
Jeśli mogę tylko dodać, w pełni się zgadzam z tym, co powiedziała Renata. Jeżeli popatrzymy na rozwój w Polsce systemu prawnego i prawa dyskryminacyjnego, to obecnie był wymuszony tylko i wyłącznie do przepisów Unii Europejskiej, że zrobił wszystko, żeby tych przepisów nie przyjąć. Zrobił to w momencie, gdy Komisja Europejska wszczęła postępowanie przeciwko Polsce. Ustawa, którą żeśmy przyjęli, jest jednym z najgorszych aktów prawnych, jakie widziałem na oczy. Napisana jest kompletnie nieczytelnie i w bardzo zły sposób legislacyjnie. I też to, co rząd mówił w związku z przyjęciem tej ustawy, było zupełnie innym przekazem do społeczeństwa. Znaczy, rząd pokazywał, zmuszeni byliśmy przyjąć te przepisy. Wcale z nimi nie zgadzamy, wcale ich nie chcemy. Musimy je stosować. W tym momencie, gdy mamy takie podejście do legislacji i na wszystkich poziomach staramy się jej nie wprowadzić do praktyki na poziomie rządu, na poziomie potem osób, które stosują to prawo. To jest wiadomo, że prawnicy są jednym z najbardziej konserwatywnych grup społecznych i bardzo ciężko się adaptują do zmian. To takie prawo nie ma sensu jak w praktyce, ono nie będzie, zmiany będą zbyt wolno idące. Prawo nie jest tym sposobem, tym środkiem, które może rzeczywiście zmienić społeczeństwo. W krótkiej perspektywie, w długiej tak za 70-80 lat zapewne będziemy widzieli ten postęp, ale w krótkiej nie spodziewałbym się specjalnych zmian. Nie prawo jest tym instrumentem, który może coś zmienić w tym zakresie.
Yeah, I tend to agree with that point actually. I'm a lawyer by background, so I continue. All right, so now I'd like to come back to the question about the Fundamental Rights Agency first and foremost. The European Union Monitoring Centre on Racism and Xenophobia, on which the Fundamental Rights Agency basically was focusing exclusively on racism and xenophobia, and I do think that the Monitoring Centre and the agency have played a very important role in anti-discrimination. However, not in terms of impact, but in terms of assessing what the problems are. In reality, and excuse my skepticism here, a lot of what the Fundamental Rights Agency has been doing is commissioning research, analysis on legal framework, social realities, and the EU Midwest report came from the Fundamental Rights Agency. For the first time, thanks to the Fundamental Rights Agency, we have a clear picture of what ethnic minorities are facing in Europe with numbers, with figures, rather than NGOs saying, you know, this is what people are facing, or rather than anecdotal evidence. That, however, has seemed to not pass the message on to the lawmakers in Europe to pass legislation to improve on that situation. As I mentioned, there is the horizontal directive which kind of builds on a lot of the research that the Fundamental Rights Agency has covered. But again, that is being stalled by member states, and that is where the biggest problem lies in terms of member states. They do not want to implement legislation which holds them accountable for equality in reality. I don't know whether that answers the question. Regarding your point on law and how that affects social change, in Malta the experience with disability legislation is a bit different from the experience described in terms of Malta. The first equality legislation that Malta adopted was in 2000, and that was the Equal Opportunities Persons with Disability Act. And that also set up an equality body. In 2004, the Gender Equality Act was passed through Parliament, and that also set up a separate equality body. In 2007, we implemented a legal notice, a subsidiary legislation, which gave the equality body on gender, the National Commission for the Promotion of Equality Between Men and Women, competence over racial discrimination. The difference is, if I go to an employer and tell him, if you do not fix this, I'm going to report you to KMPD, within a week they change it. If I go to an employer and say, if you don't change this, we're going to have to report you to NCPE, they tell you go ahead because NCPE is entirely useless and they won't do anything about it. And that's the reality. I mean, if you look at the equality bodies across Europe, and I'm mentioning Malta just because that's the one I feel safest discussing. There was, a couple of weeks ago, the Maltese government issued the budget, and the National Commission for the Promotion of Equality, because they changed the name now, so they cover both gender and race. They issued their commentary about the budget. Race, ethnic minorities, anyone who is not a gender minority was not mentioned in the reaction. It felt like the reaction was basically coming from the National Commission for the Promotion of Equality between men and women, again back to 2006 when they didn't have competence on race. And I think if we want some change to happen, and potentially not in the public attitude so much as in the way businesses and private parties actually act vis-a-vis minorities, we need to have institutions enforcing legislation that are actually there and committed to the cause that they're there for, but also have the legal backing to actually impose penalties, etc., etc. And that, in more ways than one, I think will be slightly more effective. And that is how, for example, the smoking legislation in Malta had exactly the same impact. You had a lot of people like, you never find people smoking in restaurants and bars anymore. That's because if you smoke in a bar, you get a 2,000 euro fine. If you don't employ someone because he's black, you get told that potentially, maybe within 3 years, you get told that you shouldn't have done that, but you don't really get punished for it. So, you know, there's that difference, and that reflects the difference in attitudes. On a positive note, the fact that legislation doesn't always affect social attitudes is, in some context, potentially a good thing. And linking to what you said, in 2009, under the Berlusconi government, so I'm attacking Italy, but it was under a Berlusconi government, so it's kind of, you know, within that context, passed the National Security Bill. And part of that, they actually criminalized being an irregular immigrant in Italy. Luckily, I'm hoping that it will have the same effect, or rather not have the effect, just like other areas of legislation, in shifting public attitudes in that regard as well. So hopefully, you know, we'll get the benefit out of that non-impact in that context. So.
Maybe a very small point about FRA, because that's something which is important to know, that FRA is something the member states don't want. They don't want another human rights watchdog. And in order not to want it, I mean, that's the last thing they want. They have Strasbourg, they like to pay, they don't like to change the laws. Paying is easy, legal change is difficult. So the last thing you want is yet another human rights watchdog. And in order to sort of stall it, the rhetoric is that Lisbon was about bringing democratic legitimacy back to the EU. Now, if you have FRA, look who is going to be speaking in FRA. I mean, all these NGOs, where do their legitimacy come from? Who are these people? So if it's not, so in a way the democratic legitimacy argument is turned upside down, And you can show that, of course, there are these dubious human rights defenders who are screaming against national governments, and do we want to provide further forum for that? Because if not, then don't have FRA, and one of the problems is solved and the EU becomes more democratic. So that's also, I think, part of the story about why the national governments are not particularly in love with the idea of having the human rights watchdog and having a robust institution out there.
And you can contrast that with how member states react to, for example, Frontex, which is the border agency of the European Union. And with that, member states are very happy to support, usually. And except with Malta, when they said they're going to disembark people in Malta, but that's a different question. Because that's pursuing interception measures effectively. Member states are very, keen on supporting, and we have a new regulation now that's going to increase the powers of Frontex and increase the budget of Frontex, etc. But then the fundamental rights agency is being kind of sidelined more and more as time goes by.
I was just going to say.
Okay.
I liked your smoking example. Perhaps it can be known as the smoking gun. Is that translated?
Nasz czas dokładnie minął. Jest 12. Ja chciałem bardzo Państwu podziękować za ranne wstanie i przybycie na tą sesję. Zaprosić na coś odświeżającego, kawę, herbatę i zaprosić również na sesję, która będzie zacznie o 20:30. Dziękuję bardzo pięknie.